There we go. All right. Hello, everyone. And thank you, Maggie and Ryan, for all your assistance and your technology and all of that. And as she introduced you, I'm Bev Jones. And just to give some reference, I am a fifth generation farmer and manage our family farm, as well as having my law practice, and I've been in practice for almost 23 years, actually over 23 years. And now that just made me feel older. So what I'm going to do is share with you about estate planning, some what's and how's and who's and when's, and some basic information so that hopefully you have something to take home with you to think about when you're working on your own estate plan. So let me get to screen sharing here and click the right buttons. And I'm going to change my display settings. And hopefully you all are seeing my full screen now.
Yep, you're all set, Beverly.
Okay, great. Thank you so much. Okay, so estate planning 101. We are going to talk about estate planning in very general terms. The focus tonight is going to be learning the words associated with estate planning. It's going to be learning the process associated with estate planning, both the physical process as well as some of the thought process. And then learning areas to watch out for or to think about when you're working on your own estate plan. So this is going to be a general understanding, but I want everybody to start out with a basic premise. And that first premise is that everyone's situation is unique. Each of us have our own sets of assets, our own family dynamics, our own desires, our own goals, our own objectives. That makes each estate plan unique to the person. So that's an important thing to remember. And part of that is, and this is where I put my plug in, for people to consult an attorney when you're serious about an estate plan, especially if it's going to be a multi-generational plan, if it involves real estate, farming interests in particular. It's important to consult an attorney because you're going to hear a lot of words, a lot of terms, and we're just looking at the tip of the iceberg. And a good estate planning attorney is going to be able to help you see more of that ice that's under the water. The second premise is that there are many, many different tools that we have available. And we're only going to be looking at a few of those tools tonight. So why do estate planning? We do it because we want to preserve a person's business, their investments, their labor, their property interests. And we want to provide for their welfare as well as the welfare of their family. And ultimately, to look at the disposition of those assets and those investments at the time that a person dies. We certainly all have one thing in common, and that is we have a limited lifespan. So what happens to your stuff, your business, your assets, your family when you pass away? So the way to get started is to quit talking and begin doing. And this is what I'm encouraging you to do with your estate plan. Start doing, because there is some action that you're going to have to take. Tonight, we're going to do an overview. We're going to look at some processes and look at the terms that are often used in estate planning. And then we're going to look at estate planning in a two-phase aspect. We're going to look at lifetime planning, and we're going to look at post-death planning. And those combined together create your total estate plan. So, estate planning process. The first thing that you're going to do is to define your goals and objectives. The better your goals and objectives, the better insights you give to this, the better your estate plan. The next thing you're going to look at is finding an attorney that you can easily talk to and who's going to listen to you. Some of the criteria to think about is this an attorney that's in your geographic area? Do they understand items that may be unique to you? For example, is your land sitting next to the Missouri River? Do they understand riparian rights? Do they understand relictions and accretions of land? Is there something unique about your farmland? Does it have a wind turbine on it? Do they understand the implications of the wind turbine contracts? And is this an attorney that routinely does estate planning? You're going to see that there's a lot of technical aspects to estate planning, and you certainly want to make sure that whoever you use is comfortable with those. Do they listen to you? Do they talk to you alone? When you meet with an estate planning attorney, the attorney should be looking at who is my client, and do I have any conflicts of interest going on here? Your attorney should represent you. It's your estate plan, it's your assets. It's not your children's assets. It is not your parents' assets. It's your assets. So your attorney should meet with you and should be willing to talk with you alone. And they should be able to, or be willing to answer questions in a timely manner. Everyone needs to look up answers at some point. So the question is, did the attorney get back to you in a timely manner when they had to look something up, or did they simply know it? So the attorney is going to convert those goals and objectives that you come up with into documents, and those documents need to meet your purpose. And then once you get those documents in hand, big one, review, review, review. How many of us have used spell check to find out that the word what and hat are both in spell check, and it's simply a one-letter difference? It's very important to review those documents, both for the goals and objectives, are they being met, but for the typos. Everybody does typos, we're human. Once those documents are reviewed and they're ready and you're sure that they meet your needs, then you're going to execute them. And we're going to kind of walk through that process of what it means to execute an estate planning document. And then it's going to get recorded. And if there's real estate involved, we record in the Office of the Recorder of Deeds, or we file documents at times. And when we file documents, that's usually with a probate court of some kind. Filing documents is not necessarily required, but in certain situations it would be advantageous. So then we're going to periodically review that estate plan. Rule of thumb, about once every 3 years, you should pull your estate plan out, take a look at it, dust it off, and see if it still meets your needs. And if there's any significant life issue that comes up, then you also need to pull out that estate plan and take a look at it. Things like divorce, marriage, purchasing a significant asset, selling a significant asset, having grandchildren, having children, the whole process, anything that might have a significant impact to your family or to an asset should make you go, gosh, maybe I should take a look at that estate plan. So let's learn some terms. And there's going to be a bunch of them, and I'm going to do them pretty quick. First one is last will and testament, sometimes just called a will. This is a person's verified statement regarding who they want to take care of their estate, their assets, and where they want those assets to go. Testamentary intent. This is a person's desire regarding what they want to have happen with their stuff when they die. Intestate succession. This is how assets are distributed based on state statute when someone dies without a last will and testament. Personal representative, executor, administrator, or sometimes you also hear the term executrix. We don't hear it very often, but it's actually one of my favorite estate planning words because it's kind of fun to say. This is the person in charge of a probate estate. Beneficiary, not to be confused with heir. A beneficiary is someone that is named in a testamentary document like a will or a trust to receive something. An heir is related to you based on lineage. It's a legal descendant. Sometimes you'll hear the word consanguinity, meaning connected by the blood. Trust. Trust is a contract that creates a property interest that's held by one person, the trustee, at the request of another person, the grantor or the trustor, for the benefit of a third person, the beneficiary. Our next one is revocable trust, and we have also irrevocable trusts, and they are exactly what they sound like. A revocable trust is a trust that you can amend or terminate. An irrevocable trust is a trust that once established is not to be amended or terminated. Probate. This word we actually use in two ways. We use it as an adjective and as a verb. When we use it as an adjective, we're usually talking about a probate court. And that's the court that maintains the proceedings to deal with somebody's estate or a decedent's estate. When we use it as a verb, we're using it as an action word for the filing of a will with the probate court. So we have the probate court, then we have probating a will. Simply filing a will with the court does not open up a full-blown probate estate. The next one is non-probate transfers. Transfers go through probate if they're related to a will. There are ways to transfer assets without going through probate, and those are non-probate transfers, and we're going to be talking about a few of those tonight. Then inter vivos simply means during lifetime. Advance directives. These are instructions that are given in advance of a time when you don't have the ability to give instructions any longer, perhaps because of an incapacity, which is considered a lack of a physical or a mental capacity, or a disability, which could be an impairment to be able to do a task. Then we have a living will. A living will is a type of advance directive, not to be confused with a last will and testament. A living will is a document that says, I don't want to be artificially kept alive. I don't want heroic measures used in my last days to artificially keep me alive. A power of attorney is also another type of advance directive. And we're going to talk a little bit more about powers of attorney this evening as well. But powers of attorney are a document that gives your attorney in fact, as opposed to attorney at law, attorney in fact, or your agent, the ability to take care of matters for you, either in your stead or when you can't do it yourself. Durable, a very important word. Durable means that the document is going to last and still be effective, even if you're deemed incapacitated or if you're deemed disabled. Durable becomes very important when it's a term within a power of attorney. Springing. We also see that used with powers of attorney. That means that the document will spring into effect when something happens. For example, a healthcare power of attorney could spring into effect when somebody becomes incapacitated or disabled. Gifts. It may seem strange to include gifts in an estate planning discussion, but we use gifts a lot. And for a gift to truly be a gift, you have to have three factors. There needs to be a willing giver, a willing recipient, and you need to have a release of control. And we're going to see a little bit later when we talk about non-probate transfers where that release of control is very important. Marital interests. When you get married, your spouse has an interest in your assets. There are a lot of ins and outs. We're talking estate planning here, not divorces at this time. So there are some marital interests that a spouse can have when somebody dies. So just be aware of that. Fiduciary relationship. When somebody is acting on behalf of someone else, it creates a fiduciary relationship. We see this when we talk about trustees in a trust, or agents in a power of attorney, or personal representatives under a will. A fiduciary is a very special kind of relationship. It has a higher level of accountability. As a matter of fact, a fiduciary has to look out for their what's called the principal or the beneficiary of their efforts, has to look out for that person's best interest before their own, which sometimes makes it a little difficult, especially if the fiduciary is a family member. Estate tax and inheritance tax. Estate tax is basically a tax imposed on the transfer of property. by a will, by a trust. Inheritance tax is a tax that's imposed if you inherit property. In the state of Iowa, we have an inheritance tax that is based, the percentage is based on how closely related you are to a decedent. For example, if you're a child or a parent, there is no inheritance tax. But if you're an uncle, a great aunt, there would be an inheritance tax. The farther away from the decedent you are in the bloodline, the greater the tax. Business entities. There's a bunch of them, everything from corporations to sub-S corporations, C corporations, limited liability companies, limited liability, limited partnerships, associations of persons. All of those can be implicated in estate planning when we start talking about succession planning. Guardianship. A guardianship is a creation of the court. You go to court to get a guardianship over somebody so that you can help them with their health care issues. We call it the guardian of the body, as opposed to a conservatorship. It is also a court-created entity. And we think of conservators being responsible for the money. So it's guardian of the body, conservator of the estate. HIPAA. Health Insurance Portability and Accountability Act. This is the federal law that says that we cannot inappropriately share somebody's personal healthcare information. When I was growing up, we used to be able to open the newspaper up and we could see who checked into the hospital and who checked out of the hospital. That was pre-HIPAA. You won't be seeing that now, and nor have we for quite some time. Succession planning. This is a way to try to pass on a business entity or a business interest without liquidating it. And then basis. The basis is the value or the tax basis attributed to an asset. And that becomes important because we have certain aspects called, for example, stepped up basis when somebody dies, where the recipient of the asset gets the fair market value of the asset as their basis. Otherwise, with gifts, the basis becomes to the recipient is the basis of the grantor. This becomes really important if somebody has to sell an asset. Are you going to pay a bunch of capital gains or are you not? Are you going to be able to sell it at fair market value after somebody dies and pay no capital gains? Or did you receive something by gift and therefore your basis is theirs? I'm going to emphasize this one other way. Let's say that you inherited some farmland, and that farmland is, the fair market value is $10,000 an acre. Great. If you inherited it, you get the stepped up basis. Your basis is $10,000 an acre. But let's say that same acre of farmland was gifted to you by your parents. And let's say that they bought that farmland way back when for $500 an acre. Well, if it was gifted to you, your basis is $500 an acre. So if you need to sell that property and it's worth $10,000 and that's what you're going to get paid for it, then you're going to pay capital gains on $9,500 an acre, or that's where the capital gains calculation is going to go. So those are some of the basic terms that we use in estate planning. There's many others, but these are some critical ones. So let's talk about lifetime planning. What tools can we use during your lifetime for estate plans? Advanced directives. Remember, these are documents where you say in advance what it is, who you want to have take care of yourself. Whether it's through a power of attorney, for example, for healthcare or for financial measures. Now, a benefit of a power of attorney is it allows you to avoid guardianship and conservatorships in most situations. So this means you get to choose the person that you want to have help you with your finances and your healthcare. Court does not have to appoint them for you, so it keeps the court out of your business. They can be durable, which means they continue after you're incapacitated or disabled. And you need to name people that you trust in these documents. A takeaway for you all is that consider when you create a power of attorney, consider having a laundry list of people that are going to do these actions for you. For example, if you name cousin Bob as your agent under a financial power of attorney, what happens if he predeceases you, or he decides he doesn't want to do it anymore, or maybe he's incapacitated and can't do it anymore? Have you named somebody to take his place? And what if that person becomes disabled? Have you named somebody to take their place? What I like seeing is at least the list of 3 names and hopefully 4. So if not A, then B, if not B, then C, if not C, then D. Same thing on healthcare powers of attorney. Also in healthcare powers of attorney, you can specify things like organ donation, whether you want to be an organ donor or a whole body donor. Right of sepulcher, that is the ability to make decisions about somebody's funeral arrangements. That can be spelled out in healthcare. Both powers of attorney should have HIPAA releases. Healthcare, for the obvious reasons that the doctors need to be able to talk to you if you're making healthcare decisions for somebody. And financial, let's say you're paying the bills to the doctor. Those are covered by HIPAA, the information on those bills. So you want people to be able to talk to you. Living will. Again, this is the document that says that you do not want to be artificially kept alive during those last days. This is a fundamental constitutional right. You have the right to control your own medical care and your own decisions, including whether or not to withhold or withdraw heroic measures. Heroic measures are things like CPR, respirator, feeding tubes. It could be antibiotics. It could be surgery. It could be dialysis. A living will must be in writing. It absolutely must. We have way too many cases of what happens if somebody passes away and a hospital or a doctor will not remove heroic measures from that person, even though there may be no brain activity. And in some states, such as Missouri, it's required that a copy of your living will be lodged within your medical file with your primary care physician. So when you have these documents and you go traveling, take them with you. Also, let your attorney in fact that you name know that they've been named, and be really careful of using stock forms. There's some things that can really trip you up on those. Non-probate transfers. These are transfers, again, that go around probate. So they are not going to go through your will. Okay, your will is not going to have anything to do with these. This is the most common that you will see is POD or TOD. Stands for pay on death or transfer on death. And we see those on bank accounts, investments, life insurance. The next one is a beneficiary deed. Now, this is not available in Iowa. And one of the reasons I bring it up, other than the fact it is available in Missouri, it is not available in Iowa. And there was actually a case this last July where the Iowa Appellate Court, it was called King versus Smith, where the Iowa Appellate Court said, you know what, doing a deed, signing it, sticking it in your desk drawer, hoping that somebody finds it after your death and records it to be able to transfer the property to whoever you named, is basically a beneficiary deed, and it is not an option available to you in Iowa. And in that case, the land then had to go through probate. So instead of being a non-probate transfer, it had to go through probate. So don't think that sticking something in a desk drawer, a deed, is sufficient. And here's one of the big issues about that. Remember when I talked about gifts, that there were 3 aspects to gifts? When you do that, you never gave up control. Putting that deed in the desk drawer and not recording it does not give up control. Therefore, it is not a gift. Life estates. This is a little different. This is where you sign a deed and you say, I'm giving my son and my daughter my real estate, but I'm going to retain lifetime use. I'm going to get to live on it. I'm going to get the benefit of it, the income from it. I am responsible for the expenses of it. But I cannot commit waste on it. I can't sell it usually, and I can't pledge it as an collateral on a loan. And I have to give up ownership. So that becomes a little dicey from the standpoint of the farmers, at least in my family, don't like to give up control of land. But it is an estate planning tool that can be very effective in the right situation. And then trusts, and we're going to talk about trusts a little bit more. Gifts. Remember, I talked about gifts were an important thing. A couple things to be aware of. Gifts to minors. We have what's called the Uniform Transfer to Minors Act. If you give a minor an asset of greater than $10,000, generally there has to be a court proceeding. So be careful about that. Also be careful if you're gifting land to minors. They don't have the ability to contract. They don't have the ability to sell or sign a sales agreement or a deed. So it's kind of tough if you need to do something with land and you gift it outright to minors. This is a place where a trust is handy. The other thing is, if a minor has ownership in real estate or in any asset, really, they have the ability to disclaim a transfer of that later on when they turn of age. So minors receiving gifts that would be considered titled assets, not really a great idea. There's better ideas out there. Gift to others. So this becomes interesting because this is a really good estate planning tool. Any person can give, as of the year 2022, any person can give $16,000 per person per year. So I have 3 nephews. I can give each of my nephews $16,000 every year without having to worry about any gift tax. If my husband Paul joins in the gift with me, we could give $32,000 to each one of my nephews every year. So this is a very beneficial way. If somebody has an estate that's a little bit too big and a little too liquid, we can start doing some gifting without any tax implications. We have a second federal law, and this talks about lifetime cumulative giving. And this is in addition or exclusive of the prior 16,000 per person law, which, by the way, that 16,000 goes up every year. This cumulative giving looks like this over the years. It's called a basic exclusion amount. And so 10 years ago, basically it was 5,250,000. We're now up to the 12,060,000. It increases basically every year. This amount is what any individual can give away during their lifetime or upon their death. So it is cumulative. It's very important to understand that. The other thing that's important is that if you fall under this statute, not the 16,000 a year statute, but this statute where you're talking about cumulative giving, then generally you need to file a gift tax return, even if there is no tax due. And you want to stop a statute of limitations from running, basically. But you want to put it out there that the gift has been done. Something to look at if you have to pay tax on gifts. Gift tax rates are much higher than individual tax rates. So you're looking at $10,000, anything between 10 and 20,000, it's at a 20% rate, whereas individual tax rates are 10% at the $10,000 level. So the reason I'm showing you this is just simply so that you understand when we start getting into taxes, gift tax, estate tax, tax on trust income, the rates are substantially higher than if it was taxed to the individual. That's a takeaway for you. Trusts. What's the purpose of a trust? A trust is a way to manage your assets, to control your assets, to designate who you want to take care of your assets when you can't do it yourself, and to express what you want to have happen with your assets at specific times. It could be during your lifetime. It could be upon your death. Trusts are lifetime tools, but they are also post-death tools. The benefit of a trust is that you avoid probate. This is a type of a non-probate transfer. So it avoids probate. It allows for more elaborate estate planning techniques to minimize estate tax simply because of the type of tool it is. It's private. You don't have to publish anything. When you file a will and open up a probate estate, that becomes public information. Trusts are not public information. Trusts are a great way to provide if you have a spouse or a child or a grandchild who may have some kind of disability and may receive state assistance. And also, trusts allow you to marshal your assets, to gather them together during your lifetime, which makes it simpler upon your death for your family to take care of your estate. Trusts can be amendable, they can be revocable. We have different types of trusts. Again, revocable and irrevocable we've talked about, but you'll hear the terms testamentary trust or inter vivos trust. Testamentary trusts are trusts that are created by a will, for example. The will says, I leave everything to my trust to be created under the terms of this will. Or inter vivos trusts. Those are trusts that are created during your lifetime. Nice thing about revocable trust, any income or expenses incurred by the trust get reflected right on your own personal 1040 form. It's a very nice thing. Irrevocable trust or irrevocable trust, depending on how you want to say it, requires its own tax ID number, requires its own tax return, and basically has a higher tax rate than you would as an individual. We can have honorary trusts, which take care of things like pets. You can have charitable trusts. They can be private charitable trusts that are for specific persons, or perhaps they're a charitable trust for a specific purpose. We have a trust in my hometown that's sole purpose is to assist with medical care within the county, and has put a lot of people through nursing school or nurse practitioner school, paid off a lot of debts of doctors who have come into the area. And you might have what's called a cypre trust. And this is a trust where the terms of the trust as expressed cannot be met exactly the way that they need to be met for whatever reason. They're just impractical. And a court can come in and say, yeah, but we can come close enough to the purpose of the trust that we're going to let it go forward under these constraints. And that's called a cypre trust. So uses, you can use them for your own day-to-day use. You can use them to create an educational trust. You can take care of a dog. Trusts are very, very flexible and fluid. You can use them for a lot of things. Powers of trustees are vast. They are vast and expansive. We have statutory powers as well as those that are built into the trust as a contractual power. So if you could do it with your stuff, we can have a trustee do it with your stuff for the most part. Medicaid planning. Not something that you want to go into lightly or quickly. The purpose behind it, and yes, danger, tread carefully. The purpose is that many in our society have insufficient assets or resources to provide for long-term care, such as nursing home care, which can be very expensive, $5,000 to $6,000 a month potentially. So a lot of people don't have a $60,000 income flow, especially if they are retired. So Medicaid provides funding to fill the gap, to make sure that people are cared for. It's available with certain assets and income limitations. Asset limits can be, let's see, in Iowa, I believe it's $2,000 for an individual and $3,000 for a married couple. There is some exempt assets that don't get included in the calculation up front to qualify you. Income is limited to $2,523 a month. And there are some exempt assets, I think I said, that you don't have to include to qualify. However, you do have to look at them for reimbursement. And probably one of the largest concerns, back to gifting, I told you gifting would come up again and again in estate planning. If somebody gifts an asset for less than fair market value within 5 years of applying for Medicaid, then Medicaid will take a look at that and say, you know what, there's a penalty period, and you're going to have to pay out of pocket the fair market value of that asset that you transferred before we will pay $1. And there's quite a calculation that they go through to get to that. So Medicaid planning, do it with somebody who's qualified to help you walk through the process, because it is very detail oriented. Post-death planning, tools in place during your lifetime to put to work after your death. Last will and testament, the thing that sometimes people confuse with living will. This is the actual last will and testament, your expression of what it is that you want to have happen with your stuff. This is a probate transfer. A will requires a probate estate to designate the personal representative or the executor of your estate to be able to give them the legal authority to act under the terms of your will. So the purpose for a will, the final and solemn declaration of a testator's wishes of the disposition of his property. So what kind of types of wills do we have? Well, we've got the standard will, which basically leaves everything to individuals. We have a sweetheart will. You'll hear that term a lot. That's usually where you have a husband and wife, and the wife says, I leave everything to my husband, and if he predeceases me, to our kids. And the husband says, I leave everything to my wife, and she predeceases me, everything to our kids. So sweetheart wills or mirror wills. There are other different types of wills. These are the two primary ones that we see. A lot of times if somebody has a trust, the will basically says, I leave everything to my trust. And we use it as a safety net to make sure that everything that needs to be in the trust is in the trust. So who can make a will? You have to be 18 years of age or older, sound mind, emancipated minor, or on active duty. And I think in the state of Iowa, I believe you can even be a 16-year-old, if I'm not mistaken. But in any case, you need to have sound mind. And we use the word testamentary capacity. Testamentary capacity means that you have to understand the natural objects of your bounty, and you have to understand the nature of your estate. So who are your heirs? Who are your children? What do you own? Those are the very basic things that you have to understand to have the capacity to execute a will. When we look at testamentary capacity, any mere deterioration in physical or mental powers doesn't automatically destroy it. Neither do idiosyncrasies or peculiarities, hard word to say, or abnormalities. You can have somebody who is very unique, unique enough that people go, wow, is that person a little loopy? Possibly, but that may not be enough to say that they don't have testamentary capacity. Testamentary capacity is the lowest level of legal capacity that you can have and execute a binding document. Somebody who has testamentary capacity may not have a high enough legal capacity to execute a business contract, for example. A will has to be in a writing. It has to be in a writing. We don't do oral wills. There is no such thing as an oral will in the state of Missouri or the state of Iowa. Those are called gift causa mortis. Don't work. You can have a handwritten will. That's a holographic will. You can write it on toilet paper, so long as it meets all of the other requirements to be a binding will. For example, there needs to be witnesses. Should be 2 witnesses. They really should not be the people who are going to inherit under the will. And the highest and best is to make that will self-proving, which means that there's a notary block on there also, with a notary who watched the testator as well as the witnesses sign. There needs to be publication. And publication may be kind of an odd term, because we're going to use it again a little bit later when we talk about probate. Publication in this case is basically turning to the witnesses and saying, thanks for being here. What I'm signing is my will. That's publication. So what needs to be in a will? What does the will have to say? You know what? There are no magic words in a will. It needs to be straightforward. It needs to be clear. Now, there are some things to put in a will that are better than not. But if you wrote down on a piece of paper, I leave everything to my stepson, Andy, and you have two witnesses and a notary, you have a binding will that's self-proving. So what do we look at then on contents? If there's any ambiguity in the will and it goes in front of a court to interpret it, the court is going to look at what's within the four corners of that will. What are the words that are there? They're not going to say, what did he mean by this? They're going to look at what is on that document. When we go outside of that document, we try to bring in oral testimony, that's collateral, testimony or parole evidence. They'll only do that if ambiguity is so substantial within the document that they cannot make heads or tails of what's within the four corners. Again, another reason to make sure that that document is clear and says what it is that you want it to say. Personal representative. Who is it that you want to take care of things for you? Who do you trust to take care of your assets and to make sure that the people you designate get the assets? And how are they going to do that? Are you going to leave everything equally to everybody, to all your children, for example? Are you going to divide a farm and say, I give it half of it to my son and half of it to my daughter, but I want to put a right of first refusal on the daughter being able to sell the farm so that the son could buy it? And this is where we start talking about equal versus equitable. Equal and equitable are not necessarily the same thing. A prime example would be you have a farmer who has two sons. Not that I'm prejudiced against daughters, but somehow sons come up more often. But you have a farmer with, let's say, two daughters. And one daughter stays on the farm, works on the farm, tills the soil, helps with conservation, has been on the farm for 25 years. That is her income. That is where her livelihood comes from. The other daughter went to college, went to medical school, is a cardiologist in Chicago, makes large 6-figure, 7-figure income. Okay. Well, the dad dies, leaves the farm equally to the two daughters. What just happened? What happened was equal. But that also means that potentially the on-farm daughter just lost her livelihood. Okay. So equitable may not necessarily be equal. And when this situation arises, I very much encourage people to talk to that next generation. I've had situations which have been very similar to this, where the child that's making the substantial income says, you know what, I'm okay. I would much prefer that my sibling be okay also and have the farm. Just give me some of the heirlooms. I'm okay financially. So you need to look at equal versus equitable and look at the what ifs. What if you name somebody to receive a certain portion of the farm and they predecease you? Or what if they become disabled and they're now receiving state assistance, and the minute that you give them an asset of substantial value, they get kicked off the state assistance? So there's a lot of things to think about. Do you include language about what happens if you have a beneficiary with an addictive condition? Are you going to hand somebody who is on meth a chunk of change? There could be a death warrant. So what doesn't work? What doesn't work is putting, like my grandmother did, writing somebody's name on a piece of paper and taping it up on the bottom side of a table or a chair or a vase. That is not legally binding. Don't put the deed in the desk drawer. Don't give verbal instructions because it's not legally binding. And remember, a will has no effect to transfer assets unless it is probated and a personal representative is appointed. So some of the good ideas that you can do in a will, you can put a list, if the will provides for it, you can keep a list of tangible personal property and who you want it to go to. Sign it, date it. The most current one of those lists trumps. Keep it with your will. You can ask for independent administration in the will. That allows your personal representative to do what they need to do to take care of your estate without having to go to court under a supervised administration and request file a motion and request an order every time they need to do something. And then make the will self-proving. And we talked about that with the notary block. So what happens if you don't have a will? We're going to go through this pretty quickly. I want you to think of a fountain as we go through these examples, okay? So if there's only a spouse, then it's all to the spouse. Think of the estate as a body of water, okay? It's a pool of water, and that's you and that's your estate. And your spouse is in that pool of water with you. So if you aren't in the pool, it's all going to the spouse. So what if there is a spouse and children, and those children are all in common? Stays with the spouse. What if the children are not all in common? Well, then the spouse is going to get half of the real estate, half of the non-exempt personal property after the debts are paid, all of the exempt personal property, and enough assets to equal $50,000, and the rest goes to the children. What if there's no spouse? Then it all goes to the children. What if there's no spouse or children? Now, remember the body of water, you and your spouse in the pool of water? Children are down the drain. So the water drains down first to children, right? Okay. What if the drain is plugged? There is no spouse, there are no children. Then we're going to allow that water to spurt up to your parents, to that prior generation, or to your parents or the survivor of your parents. What if there's no spouse, no children, or parents? Then we're going to spurt up to mom and dad, and we're going to watch that water fall down on the fountain to the issue of mom and dad. Okay, so siblings and nieces and nephews. What if there is no spouse, children, parents, siblings, nieces, and nephews? Then we're going to spurt up even higher on the fountain to the paternal grandparents and maternal grandparents. And then we're going to follow the water down to uncles and aunts and so forth, okay? Cousins. So we spurt and we go out quite a ways. So sometimes I have people come into my office and say, if I don't do something, the state's going to get all my stuff. Well, we have a lot of stuff to go through here, a lot of people to go through before the state would ever take anybody's assets. Probate. Remember that a will has no effect unless it is probated and a personal representative is named. The purpose of probate is to give somebody the legal authority to handle another person's stuff. A will has to be probated in Iowa, means filed with the probate court within 5 years of date of death. If that does not happen, then it's as if that will never existed. In Missouri, it's 1 year of date of death. I'm 10 miles from the Missouri-Iowa line, and we have plenty of people who have land that lapses, over a state line. This can become an issue. Types of probate estates. We have full estates. In Iowa, that usually kicks in if you have about a $200,000 estate. In Missouri, if you have a $40,000 estate. And then there's abbreviated estates or small estates. And those have different stratus depending on who the recipient is and how big the estate is. But they can be done much quicker than a full estate. The process. We file a petition. We designate in the petition who we want to be personal representative and executor, and that generally is the person named in the will. There's publication. Now, this one is in the newspaper. In Iowa, we run it for 2 consecutive weeks. In Missouri, we run it for 4 consecutive weeks. And we also have to send a notice to Medicaid and put them on notice that somebody died. And they will then determine whether or not they have a claim against the estate. Now, regarding claims, those are handled by the personal representative. That's who handles the business of the estate. Claims, distributions, will contests, paying bills, marshaling assets, paying taxes. In Iowa, claims must be filed by the creditor within 4 months after the date of the second publication. In Missouri, it's 2 months after personal service or 6 months after the first date of publication. Costs. Of course, there's costs in probate. We have filing fees and order fees and inventory fees that are paid to courts. There's publication expense. We usually get abstracts updated, and surveys may have to be done if the land's to be divided. Appraisals, because you want to know what that stepped up basis is. Executor bonds. These are what's called a defalcation bond. In case for some reason your executor steals from the estate, you want a bond out there to cover it. And then there's the executor and attorney fees. And these are based on inventory value. So I've given you the statutory calculation for these fees, and they are considered maximum fees. You can go above that fee if there's extraordinary situation. So for example, a $100,000 estate, the fee should be right around $2,120. For a $200,000 estate, around $4,060. In Missouri, kind of an interesting note, the statutory calculations are minimum attorney fees as opposed to maximum. And you could see that they're a little bit higher than in Iowa. Post-death concerns. Disgruntled relatives, it happens. It definitely happens. So people have the ability to challenge an estate plan for 4 months following the date of second publication. The main reason people would challenge is testamentary capacity. He didn't have the ability to comprehend the importance or the import of his actions when he signed the will. That's testamentary capacity challenge. And we usually look at that from either they didn't have the ability, or maybe they were under some kind of undue duress or influence such that they couldn't comprehend what they were doing because of somebody else's overriding will. Will being power, overriding power. Generational changes can lead to lots of disgruntled relatives. When you have a mom and a dad that are pretty much heading up the family and they pass away, and now the children are the head of the family, things change. The dynamics change, and it becomes a little more difficult unless the family is truly working together. And unfortunately, I would say that probably 60 to 70% of the estates that I see, there's some contention somewhere. So when you get rid of the mom and dad generation and you're down to the kid generation, you usually see some changes and some competition. And then family divisions. Unfortunately, that seems to happen more substantially with in-laws getting involved. A sibling whose spouse thinks that they should get something, and you start seeing families divided along family lines, you know, between siblings or nieces and nephews or so forth. So these are considerations when you're looking at your goals and objectives. How do I draft my documents to minimize family divisions, to minimize the impact of generational changes, or to minimize somebody trying to challenge my ability to create the estate plan that I want to create? And then business continuity and succession planning. Again, this is trying to pass on a business entity without having to liquidate it. So when we look at business continuity, we look at what's the current ownership structure. Is it a type of business entity that is going to allow us to pass it on to another generation or to another person and keep that business going? What are the asset values? Are we talking something that's substantial? And what kinds of assets are we looking at? If it's a farm, do we have on-farm managers or owners or family members who are actively doing boots on the ground? Are they handling the accounting, the financing? Is it operating under a crop share relationship, or is it a cash rent? Because then we start looking at passive or active interests. And cash rent is a passive interest. If you have an active interest, there's some ways to get around some pretty substantial estate tax issues if you've got somebody who's willing to continue farming that farm for another 10 years. And then funding for the next generation. So you set up this plan. It all looks gorgeous. we've heard the phrase land rich and cash poor when it comes to farming. How have you left the funding for the next generation to be able to keep the business going? In a farming context, we look at it as is there liquid assets sufficient to buy the inputs that you need to get that crop in the ground for that next crop year? What about feeding the cattle? Do you have a cow herd? Do you have some liquid assets there available to get your salt licks purchased? So how are you going to fund the next generation to keep the business going? And I throw something else out in this. I mentioned in brief, if you have a sub S corporation, be aware that a trust can only own a sub S corporation interest after the death of the grantor for 2 years. And then you have to look at revising that and figuring out where you're going to go from there. So in summary, estate planning, it affects all areas of life, your assets, your family, your care during your lifetime, the care of your body after your death, the care of your assets in the hands of your beneficiaries, and how you're affecting your heirs. It requires time and attention to put it together, to plan it, to create goals and objectives that truly carry out what it is that you want to have happen. It should be tailored to your particular situation and to your needs, and it has to be looked at as a multi-generational project. So this is what creates a good estate plan. Hopefully this has given you some generalities about estate plan and the understanding that there's quite a bit to it. And depending on how intricate your estate is, it can require several different types of documents. Even people who have a very small estate run into issues when you've got farmland that you own, and perhaps you're needing to tap into Medicaid to receive nursing home assistance. So a very broad topic, a very relevant topic to actually everybody. And I will put in my plug. I think that every single person needs to have a set of advanced directives, powers of attorney, and living will, so that you can determine what happens to you during your lifetime and not leave it up to a court to make that decision. And they're cheap. They're cheap, cheap, cheap. So I leave you with that, and thank you. And there is my contact information. Please feel free to contact me should you have any questions or thoughts. And there are lots of really good estate planning attorneys out there. I would encourage you to find one. And thank you. And I will stop sharing now.
Thank you so much, Beverly. That was great. And we have lots of questions to get through. At the very beginning, when you were talking about, finding an attorney, one thing that I was thinking about, just kind of putting myself into the shoes of somebody trying to find an attorney and imagining that there's a lot of unknowns. And so I guess what I'm trying to ask is, how does somebody feel empowered if you find somebody that doesn't feel like the right fit, but you're not sure because you feel uncomfortable with the content being shared anyways? Do you have any insights on that?
Sure. Good question. Actually, very much so. I am a consumer advocate. I believe in shopping around, and not everybody is going to be good for every person. All of us have our own idiosyncrasies, and all of us have our own approaches. So it is absolutely acceptable to meet with an attorney just to see how you like dealing with them. Okay, that is absolutely fine. And if you don't like dealing with them, if they aren't listening to you, if they aren't hearing what it is that you're trying to tell them or your concerns, or if they minimalize them, then find another attorney. There are some really good estate planning attorneys out there, and a good estate planning attorney is going to be someone who listens to you and that you feel comfortable, because you're going to be sharing a lot of information with them, a lot of very personal information. So feel comfortable. If you don't feel comfortable, it's okay to say, you know what? Oh my gosh, I have another appointment in 5 minutes. So thanks for meeting with me. Shake hands, get up and walk out. That's fine. That is fine.
Thanks, Beverly. All right, definitions. when does basis come into play again? How does it trigger the historic price? So can we just go back to basis and talk about that
Sure.
again real quick?
Basis, first understand that let's say, let's walk through a scenario. You buy a piece of land in 1980, and that piece of land has an acre, and that acre cost you $500. The moment that you bought that piece of land, your basis in the land is $500. Okay, 1980. Let's say you did some conservation work, and it was long-term conservation work that can increase your basis, during your ownership a little bit. It's going to edge it up a bit. But then let's say another 30 years goes by or 40 years goes by, and that $500 acre is now worth $10,000 fair market value. If you sold it on the market, $10,000. If you sold it, you're going to be looking at a $9,500 difference between that 500 and the 10,000. You're going to be looking at that on determining capital gains. Okay. Now let's say at that point, instead of you selling it, you pass away and you give it to somebody. Their basis is now the fair market value of that farmland. Okay. So on their books, that 1 acre will be on for $10,000. On your books before you passed away, that 1 acre was on your books at $500. Now, if you would have gifted that 1 acre to your niece, your nephew, your son, your daughter, whatever, if you would have gifted it to them at a time when that acre was worth $10,000, on their books, that acre is going to be $500, not $10,000. Okay. Because when you gift an asset, you're also gifting the basis. I don't know if that makes it clearer. So it comes in when you're looking at capital gains and values.
Okay, thank you. All right, and then when you were talking about lifetime tools, non-probate transfers, somebody asked, is there a difference between a grant of life estate and a reserved life estate, or are they the same thing?
I would say that they're probably the same thing. When you do a grant of life estate, the grantor is actually reserving a life estate to themselves. So I think it's semantics.
Okay. All right. And then when you're talking about trusts, can't trusts avoid probate? So do trusts allow you to maneuver around probate?
Yes, they are non-probate transfers.
And then can trust be set up to take care of property after you're gone?
Absolutely. That is a biggie. You can actually, I encourage people to create a trust during their lifetime, put their property into the trust during your lifetime, and that way the trustee just steps into whoever you name to follow you, because usually you're your own trustee when you can. That trustee then steps into your shoes and follows out the marching orders that you put in the trust after you either are incapacitated during your lifetime or after you die, after your death. So absolutely, that is a primary thing for trust, is to put property in it, real property, personal property, investments, not IRAs usually.
Yes. And then somebody also asked, how about gifting to a nonprofit organization to avoid paying capital gains on a piece of property?
Good question. And I'm going to deflect that one to a tax person. Reason is we've had lots of changes in our tax code. And while I have sat and passed the CPA exam, I am not a licensed CPA right now. And with all of the tax changes we've had in the last 4 or 5 years, I would deflect that to a tax professional.
Fair enough, Beverly. All right. And then when is it a good time? So this was when you're talking about Medicaid planning. When is it a good time to arrange for long-term care insurance?
That's a really good question. The tongue-in-cheek answer is at the time you could still afford it. because long-term care insurance is not a cheap insurance. So usually you want to try to arrange for it before you turn 60. That's kind of a magic number. Different companies, different places. The long-term care insurance that was available when my parents were around, 15 or 20 years ago, if anybody has one of those policies, they're usually called gold-plated policies because you cannot find them anymore. So what you get now are lesser policies, so it depends on what you want to do. Now, something that is available out there was kind of a new product that I heard about a year ago, is if you have sufficient liquid assets, you can invest, I think it's like $100,000 into a fund that takes care of your long-term care, and you can withdraw it at any point at any time. It's more of an investment approach to long-term care insurance without being an insurance policy. So it's kind of an interesting thing, but anyway, and it can be inherited if you don't use it and so forth. So there's some different tools out there.
So going back to trusts, if you're a successor trustee to your parents' trust, can you sell property in the trust?
Depends on the agreement. The trust agreement might say you're going to hold on to that property until Billy Bob turns 18, and maybe Billy Bob's only 2 at the time. It might say you're going to hold on to it during your lifetime and you'll get the income off of it, you being the successor trustee or some other person. And then upon their death, the property will go to somebody. So it all depends on the terms of the trust.
And then do you have any insight to donating conservation easements through a land trust and how that can help or make things harder potentially?
Not really. Meaning I'm not going to answer that question because I won't give you a good answer. Conservation easements do have a place and they do have a position, but it all plays into the total estate plan. So I don't think I could give a good answer on that.
Okay. All right. And then when you're talking about post-death tools, last will and testament, if somebody is in a situation that they've been separated for 20 years, can you put it in writing that you don't want that spouse to get anything when the fountain starts?
Interesting question. Well, frankly, remember when I said that there's marital interests or spousal interests that can arise? One of the things a spouse can do is do what's called take against a will. What that means is, if the will says, I want the spouse to get $5,000 and that's it, or whatever, the spouse can file a motion with the court that says, no, you know what? I'm going to take against the will, and I'm going to get everything that is due to me under the intestate succession laws, basically. I'm going to get the exempt assets. I'm going to get whatever percentage of the non-exempt assets. I'm going to get a homestead allowance. I'm going to get a family allowance. So a spouse, even if separated, unless they are legally separated, if they're just living apart, would have some ability. Absolutely. The other thing, we had a case in Missouri a few years ago where a gentleman was separated from his spouse for a lot of years, dies, and the only person that the funeral home would listen to on his funeral arrangements was that spouse who really didn't like him. So that led to a new law in Missouri on being able to name people under right of sepulcher. So it's amazing how our laws come from bad acts of people.
Yeah, one bad apple can ruin it for the rest.
Exactly.
All right, I think we've covered most of the questions. Does anybody else have any questions, or like if you want to throw something in there again that I've missed? Just scrolling down through. Well, it looks like, Beverly, we've walked through all of our questions. I I am going to send a thank you email out tomorrow to everybody that attended, and I will be including Beverly's email and phone number. So if anybody does think of anything that they would rather connect with Beverly, in private over, then you can definitely do that. Oh, we just had one question. Is there common law marriage in Iowa?
Yep.
All right. Well,
Not
and
in
then,
Missouri, but in Iowa there is.
okay.
And it's pretty fast. Say that you're married, sleep with them, live in the state of Iowa, and you're pretty much married.
Good to know.
Yeah.
Well, I'll send out Beverly's contact information. So if anybody does have any other questions that come up and they would rather connect with Beverly privately, you will have her information. And then thank you, Beverly, so much for your time. Really appreciate it. And thank you, everyone, including Beverly, for dealing with our tech hiccup that we ran into at the very beginning. Once we got in there, Beverly, it's like nothing had occurred. So thank you so much for sliding into your presentation so smoothly. Thank you, everyone, for joining us tonight. I encourage you to fill out that eval once we close out, and reach out if anybody has any other questions. Thank you, everyone, and have a good night.
Thank you.